This is Patrick Henry, the CEO of QuestFusion with the Real Deal What Matters. We're here today with Jennifer Rubin, who's an attorney with the law firm of Mintz Levin. Jen focuses on C-suite executive compensation practices and on meeting the increasingly complex employment needs of executives of public and private corporations. When she isn't negotiating employment, equity, and severance arrangements, Jen leverages her 26 years of experience as a trial lawyer, so she's a litigator, to help clients craft business solutions to legal problems. She practices law both in California and in New York. Jen has an AV preeminent ranking from Martindale-Hubbell, which publishes a highly regarded law directory that provides background information on United States lawyers and law firms. So that's the top ranking, I believe. She's also a member of the board of Big Brothers and Big Sisters of San Diego County, and is a faculty member and advisor to the Honor Foundation, which is another nonprofit organization that assists Navy SEALs and other armed services special operators transitioning from military service to the private sector. Jen is frequently quoted in the Wall Street Journal and other publications about employment topics, and is a frequent contributor to Mintz Levin's award-winning EmploymentMatters.com blog. So welcome, Jen.
Thank you.
Thanks a lot for doing this today. Today we're going to be discussing employment agreements, the different types, what are the key components of each, and why they are important for your startup, and why they're also important for companies and boards of directors, and why they would be potentially important to you as an entrepreneur. So Jen, can you describe to us in layman's terms the basic types of employment agreements?
Sure. So when you think about an employment agreement, it's really any document that governs the employment relationship.
Okay.
And it can also be oral. But when most people talk about employment agreements, they're really talking about a document that provides severance or a term of employment.
So even like a job application at the most basic level is an employment agreement because it has some kind of information in there. Once you sign that, that's basically, if that's the basic thing, that's the legally binding document.
In fact, an offer letter.
Okay.
An offer of employment that's provided to an employee that an employee countersigns and sends back, that's an employment agreement.
Okay. And that basically governs the employment arrangement unless there's something in the state that you're living in that governs things like at-will employment. So,
right.
Like, I guess California is an at-will employment state?
Yes, it is.
So explain what that means, and is that different than other states, or how does that work?
Every state is an at-will employment state.
It is,
and that
okay.
means that you can terminate somebody at any time and for any reason.
Okay.
The issues arise when there are exceptions to at-will employment. For example, an employment for a term that you have in an employment agreement that says, I'm going to employ you for a few years.
Okay.
That's an exception to at-will employment.
Okay.
And of course, the law places exceptions in at-will employment where you can say that an employer can fire somebody at any time for any reason. You cannot fire somebody for reasons that violate public policy. For example, you cannot fire somebody because of their gender, because of their age, and so on and so forth. So there are a lot of exceptions to the rule, but in effect, that is the law in California, as in most states.
Okay, so that's why there has to be some, in some cases, documentation if you're dealing with, what do they call it, an accepted class, or I forget what they call it.
A protected class.
A protected class.
But there really doesn't have to be documentation as to that because the law itself provides the documentation.
It does, okay.
Exactly.
So then you just got to make sure, if you're an HR professional in a company, you got to make sure that you understand all of those things, and if you do make a decision to terminate somebody, that you're in compliance with all of those things.
Exactly.
Okay. So with employees, I've seen these proprietary information and invention agreements. What are the key terms of those? I mean, I've been mainly working in engineering companies most of my career, developing complex technical products. So there's a lot of intellectual property, and these are the types of things I'm familiar with for the kind of rank and file employees.
Right.
So can you talk a little bit about that?
So it's important when you bring somebody into your organization and they're going to be exposed to your confidential information and trade secrets, it's important that you protect that, both while they're employed and after they're employed.
Okay.
So the proprietary information really relates to confidential information. It might relate to trade secrets, but it's important that it's clear to the employee what's yours as the employer,
right,
and what they can and cannot use with respect to that information.
Okay.
Now, inventions is slightly different. Okay, so you've been in an engineering company, and
Yeah.
the important issue there is that if somebody's working on your invention, you want to make it clear that it's the employer or the organization that owns the rights to that invention.
Correct.
Okay?
Yeah.
So that's where those agreements become very important, because you want it made clear, you're coming into my organization, I'm paying you to work on my product or my invention or my development.
Right.
I own that.
Yeah.
So after you leave employment, there's no issue or ambiguity about who has the rights to that invention.
Okay. Yeah, I mean, this has been, in my experience, important not only with employees, but also with contractors.
Yes.
Where you might have, and especially in the engineering world, there's specialists that work in a particular area, and
Yes.
they're kind of like hired guns, so to speak. And you bring them in because they might have a specialty in a particular area. You don't need them long term, but you
Right.
need them for a particular opportunity. And making sure you get the proper documentation in place and it's clear who
Absolutely.
owns what, is really important.
Absolutely. So making sure that you have signed agreements, this is
Yeah.
one of the biggest mistakes I see.
Yeah.
You may have a great form agreement. You may go out and pay counsel to prepare this wonderful
Right.
form agreement, but then you have people coming in and you don't have good internal organization from an administrative standpoint,
Right.
where you're not actually collecting signed agreements and filing them and keeping them on hand in case you need them.
Yeah, and I've actually seen this, primarily in kind of M&A transactions where, I'm with a company, we decide to buy a smaller company, they haven't done a great job of
Absolutely.
this. We're really concerned about, did they even own the intellectual property that was
Absolutely.
developed? So in some cases, it's even been a showstopper if, the smaller company hasn't put those things in place.
That's right.
Yeah, that's very important for entrepreneurs. Make sure that if you are developing anything, that you do get these
Yes.
agreements in place, even with contractors.
Absolutely.
Are there other key terms in employment agreements that a founder or CEO of a startup needs in his or her employment agreement?
So one of the things that founders in particular need to be concerned about, this is you've birthed your baby, so to speak,
Sure.
and now you're fostering it, and then you're bringing in outside investment to help bring it along,
Right.
With the hope of an exit, right? I mean, that's the general business plan.
Sure.
The problem arises when outside investment comes in, and for one reason or another, they may decide that you are no longer the key leadership that they want.
Yeah.
So from a founder's perspective, what you want to do is get in writing what's going to happen if you are asked to leave for some reason.
Right.
Okay? You're fired, in
Yeah.
effect. And that's the importance of employment agreements from a founder's perspective, or any executive.
Yeah.
Is what are the financial terms upon your departure?
Right.
And having that in writing is critical. I mean, that's not anything that the law is going to supply to you. That's
Yeah.
something that you need to have in writing, signed by both you and the company.
Right.
So very, very important for an executive who might be giving up other opportunities, for example, to come work in a certain company,
Yeah.
or a founder who's trying to get things moved along,
Sure.
and you want to make sure that you understand what's going to happen if you're terminated. Same thing in terms of what happens to the equity.
Right.
Right. You may have options that might vest, or restricted stock that that may have restrictions that would lapse upon certain events. Very, very important to get that in writing.
Yeah. So I've worked with a lot of venture capitalists over the years, and they have their own little pithy statements about this stuff, like put the founder in another area code, or CEOs come and go. So I don't have any hard statistics on this, but I mean, in your vast experience in this, how often do founders end up getting removed from their company, and how often do CEOs that get hired into a company get removed? Is it pretty high?
I would have no idea what the statistics are. I
Yeah.
do work both with companies and with executives,
Yeah.
and it's fairly common to see interests diverge,
Yeah.
let's put it that way,
Yeah.
at various points in a company's growth, right?
Yeah.
A company may start out in a certain direction. There may be new money coming in that
Yeah.
takes it in another direction, or an acquisition. So it's very, very hard for me to answer that question.
Yeah.
I will say, though, you're in a better position if everybody knows what's going to happen upon that exit.
Right.
And I really see employment agreements as the primary vehicle for determining the financial issues when an executive leaves. So
Yeah.
you know in advance, is it a year's severance? What's going to happen with the stock?
Right.
It kind of gives both boards and executives that pre-knowledge about
Yeah.
what's going to happen upon an event of termination.
And I agree 100% with that. It's interesting because I think anytime that you raise an institutional round of financing, so a Series A, and you bring venture capitalists in, if you're a founder of a company, you need to get these things put in place.
Absolutely.
And there have definitely been times in my career where the VCs are like, hey, just trust us. And it's not, from my perspective, and my answer to this isn't a matter of trust. This is a matter of clarifying how things will work in the event that things go sideways.
Absolutely right.
So it's not, if I didn't trust you, I wouldn't even work with you.
Of course.
You wouldn't ask me to sign a proprietary invention and non-disclosure agreement unless you trusted me.
Absolutely.
So it's not really about trust, and I think that's kind of a negotiation tactic that people use. And if you're a founder or you're a CEO, sometimes it's very difficult to negotiate for yourself.
Yes.
Even if you're a fantastic negotiator with customers, it's really important that you get these things put in place, because although Jen wouldn't give us statistics, it is common for these things to happen. And the time to negotiate these things is not as you're being exited. The time to negotiate is when you're bringing in an institutional round of financing if you're a founder, or when you're negotiating coming into a company if you're the CEO that's being brought in.
That's right. So think of it this way. You can't submit a handshake as Exhibit A at trial, okay?
Exactly.
So think of it that way.
Exactly, yeah. So switching gears a little bit, let's look at something near and dear to my heart, since I've been a CEO of 3 different startups and a C-suite executive before that at some technology companies. Talk to us about employment agreements in a little bit more detail about entrepreneurs and executives. I never even knew these things. This is one of the kind of big secrets in companies. You don't even know these things exist until you get to a certain level. And maybe if you're a first-time founder, maybe you don't know that these things exist. And I would say it wasn't until I negotiated my third one, maybe my second one. No, it was my third one, because I was with a big company, my second startup, that I actually had any idea what I was doing, because there's so many intricacies to these things. So I think this will be really instructive for the entrepreneurs out there. Give me a perspective, both from, since you work with boards and executives, what are the kind of big terms that are important in these things for both sides?
Right. I think the most important issue is what happens upon an exit. Okay, so everything else that you can have in there, benefits, salary, bonus, sure, those things are important. They're material terms of an employment agreement. But everybody needs to know what happens when either the founder's asked to go or forced to go.
Right.
Okay, or when the founder wants to go.
Yeah.
Okay, so those are really important issues. And when I say founder, I also mean executives, of course.
Sure.
So you know what's going to happen. So severance terms, very, very important.
Right.
Even more important, the definition of cause.
Yeah.
Okay. There is no standard definition of cause. There's no commonly accepted definition of cause. This is something that's typically subject to negotiation. It implies misconduct.
Yeah.
Okay, so that's a very kind of good starting point. What is misconduct? And of course, the company would like to have a very robust view of that, and the executive would like a very narrow view.
Right.
Okay, so it's about meeting that in the middle, because if and when it comes time for the executive to go, the issue is going to become, is it with cause, is it without cause, and what do we have to pay this person as a result?
So cause being, the reason for dismissal.
Yes.
And, I guess in my experience, that has been one of the more difficult things to negotiate, especially when you get to if there's a performance element associated with the cause. And, is there a notice period, or, as an executive, I'm totally fine with somebody saying, if you're not doing your job, I have the right to dismiss you without paying you severance.
Right.
I've never had an issue with that. My attorneys that have defended me say you don't even want that in there because it opens the door for manipulation. But I think that, everything I've had has that portion in there.
Right.
And what it does do, though, is the board has to give you written notice of what the issue is in advance, and then you have some type of cure period.
That's right.
Are you, with all the deals that you're negotiating, do you see that there's situations where there is no performance portion for cause? Are there people that get brought in that there's nothing in there like that, or is that pretty much a standard term?
I don't think there's any standard term when it comes to cause. I really don't. I think it's very wide open for negotiation. It typically implies a concept, as I mentioned, of misconduct.
Right.
Now, it is very common to ask for some sort of notice, which you think from a perspective of fairness, tell the person, gee, we don't think you're doing a good job. This is
Right.
how you need to improve,
Right.
and you're going to have a certain period of time to improve.
Right.
And if you don't, then you're going to go and you don't get severance.
Right.
Okay, so you think about that from a fairness perspective, but it doesn't always work that way.
Yeah. And the attorney that I worked with is pretty, hardcore guy, but he was like, unless you get convicted of a felony, that's the only reason that should be cause.
Okay.
And obviously the board took a different view upon those
Yep.
things. So, there was a negotiation that occurred, and whatever turned out was fine with me, because you're making a decision as an executive, especially if you're leaving another company, you're leaving money on the table. That's the time to make a decision. Am I getting a deal where, hey, I'm going to take this thing from either out of the garbage to a successful company, or something that is pre-product, pre-revenue,
Right.
to something that's a successful company,
Right.
and it's primarily equity-based compensation. You might, obviously getting some cash compensation, but the primary reason why you move from a big company to a small company is because of the equity.
Absolutely.
And you want to make sure you get that in the event you're successful, and not
Yes.
just get thrown out with the trash. And you did all these great things,
Exactly.
and so I think this is important. So
Yes.
cause clearly a key element. Are there kind of within cause? Are there things just kind of as a guideline for the entrepreneurs out there? Do you have like a checklist of things they should think about or look at, or is it so wide open you can't even do that?
It's very wide open, and of course I approach it when I'm engaged either by the board or by the executive. I
Yeah.
approach it very differently.
Yeah.
Typically, it's the company that presents the draft agreement to the executive,
Sure.
and then the executive negotiates against that.
Yeah.
So it's very hard to answer that question because my approach to it would depend upon who I'm representing.
Right.
Am I commenting against the draft? And of course, obviously, there are all those other things that come into play. How badly the company wants the executive.
Right.
What other opportunities is the executive giving up?
Right.
So the negotiating leverage is so different with in every situation that it's very hard to answer that question.
Yeah. I would definitely say if you are an executive, having a conversation about working for a company, especially a startup, these are not things that you want to bring up on the first interview.
Yes. That's true.
I think these are things that you want to wait until they really want you, until they've presented you an offer, until they're courting you.
Yes.
And then that's the time to start having some discussions around this. Otherwise, you can really shoot yourself in the foot and look unreasonable and greedy.
Yes.
So tell me a little bit about, change of control provisions. Okay. First of all, what's the difference between single trigger and double trigger and change of control?
So a single trigger change of control is when there's a basically an exit in effect, whether it's an asset purchase, a stock purchase, but a defined situation when usually a company is acquired, okay? Yeah. And a single trigger means that upon the happening of that event, the executive basically gets to parachute out.
Yeah.
Okay. I haven't seen a single trigger change of control provision in a very long time.
Yeah.
As you can imagine, they're disfavored because it may be that the new company coming in, making the acquisition, actually wants the management team to stay.
Sure.
So it becomes almost a disincentive. So that's becoming unusual. Double trigger is when there's this transaction or exit,
Yeah.
and within a certain defined period of time, the executive is terminated.
Yeah.
Okay, and at that point, the executive gets to, in effect, parachute out.
Right.
With certain benefits, whether it's equity acceleration, more robust severance is something that might typically come into play.
Yeah.
But there has to be kind of that two-step. There has to be the transaction, and then there has to be the exit associated with the transaction.
Right, right. It was interesting, in one of my companies, we actually negotiated two different definitions of cause. One that dealt with kind of the standalone company, and one that dealt with, in the event there was a change of control, the definition of cause changed around that. Do you see that as pretty common, or?
I have not seen that,
Okay.
but I could definitely appreciate and understand why that would come into play, because of course the new owners coming in,
Yeah.
they may have their own team.
Exactly.
Right, and that's fairly common.
Yeah.
Nobody really thinks that that's unusual, so you want to provide that protection for yourself.
Right. So the other thing that I had in my situation was I've always had a dual trigger, but when we had a private company, my dual trigger was that I didn't there had to be the change of control, and then I had to lose my position in terms of basic scope. But if I were a general manager for a bigger company, that's not a double trigger, even though I was the CEO of this company over here. In the situation when I had a public company, then that second trigger was changed, that if I'm not the CEO of the successor company,
Right.
then my second trigger came in. So do you see that as being pretty common?
So
or?
what you're really referring to is a good reason provision that
Yeah.
allows you to, in effect, parachute out if you don't maintain your position within the organization.
Exactly.
And that is something that is extremely common. Because
Yeah.
if you think about it, you know, you've achieved a certain level as an
Yeah.
executive, and you're
Yeah.
entitled to maintain that for purposes of your own career.
Right.
And if you're all of a sudden, you know, asked to, in effect, step down,
Yeah.
you know, several steps,
Yeah.
you should be entitled to say, you know what, I don't want to be at that level in the organization.
Yeah.
It's time for me to go.
And I saw it more common because I wasn't the only one that had stuff like that. I mean, people that were like my general counsel, my CFO, my head of HR, but people that were like in marketing positions or sales positions, they had more of the standard
Right.
double trigger as
Right.
opposed to this, what I'd call special
Right.
double trigger, where you
Right.
didn't keep your
Right.
exact title.
One thing I want to add, though, and this is
Yeah.
very important for, in fact, overall to everything relating to employment agreements and change of control or anything
Yeah.
relating to that, there are certain tax provisions that are implicated
Right.
in these agreements. Section 409A.
These are parachute payment type of tax situations.
Well, there's that too. So
Okay.
that's 280G,
Yeah.
the Internal Revenue Code. But I'm referring to Section 409A,
Okay.
which is another provision that actually penalizes executives pretty heavily if an agreement is not compliant with the tax code. So
Okay.
my advice, my general advice, when you're entering into an employment agreement, either engage, you know, employment counsel with tax expertise or separately engage an accountant, because if your agreement doesn't comply and then it turns out later that you're triggering something,
Right.
you could create a major problem for yourself.
Okay.
So this is another reason to never kind of cut and paste an employment agreement for
Yeah.
somebody else
Yeah.
and, you know,
Well,
sign on to it.
It's definitely worth it to spend the money on a not only a competent, but incompetent in terms of the technical aspects of being an attorney,
Yes.
but competent in terms of negotiation, because you're dealing with seasoned professionals on
Right.
the other side.
That's right. And when
So-
you're talking about perhaps a 20% penalty, not just
Yeah.
tax,
Yeah.
okay? A 20% penalty on all amounts
Right.
that you receive
Right.
that are deemed by the IRS to be non-compliant.
Yeah.
I would think that,
It can be massive.
compared to a couple of $1,000s for
Right.
hiring competent counsel.
Right.
Yeah, you don't want to learn that, you know, after the fact.
Yeah, that's terrific advice. So what about acceleration in equity? In my last public company, I saw a survey from one of these compensation, experts, that they said all C-suite executives are getting full acceleration on change of control in public companies. That hasn't been my historical experience. I mean, typically, like maybe the founders or the CEO get full acceleration, and everybody else gets like either 50% or 24-month acceleration. But I was surprised to see this. And is there a difference between private companies and public companies here, or what do you see as kind of the common thing going on right now?
I think the most common thing that you see is a full acceleration of
Really?
change of control. Yes. Now, there are different issues with private companies and public companies, obviously related to marketability.
Yeah.
Right? With a private company, you can't sell the stock necessarily on the open market, obviously.
Yeah.
There are also issues associated with the 280G that I just mentioned,
Right.
which is the parachute tax, what happens when the individual parachutes out and
Right.
receives all this compensation that might trigger those tax provisions. With a private company, there's certain ways that might be able to be dealt with
Yeah.
that kind of addresses the tax situation that is not available in a public company situation.
Yeah.
So certainly if I'm representing an executive, I'd like to see full acceleration, and that's what I would certainly argue for.
Yeah. But it would be dual trigger.
Yes, it would be dual trigger because, again, I haven't seen a single trigger.
Yeah.
I honestly can't remember the last time I've seen a single trigger.
Uh-huh.
But certainly you want to negotiate for that full acceleration in connection
Right.
with the change of control, because that's the whole point, right?
Yeah.
You foster this organization, you take it to that point. Newco comes in, they're either buying all the assets or the stock or whatever it may be, and that's the point of your staying and
Right.
remaining incentivized to stay. So that you get the benefit at the end. And the way to
Right.
get the benefit, of course, is through the equity.
Now, do you see 100% acceleration kind of across the board with termination without cause or termination for good reason? Or is that kind of not necessarily 100% acceleration in those cases?
I would almost always see 100% acceleration in those cases.
You do
or
as
at least
well?
that's
Okay.
what I certainly try and negotiate for
Sure.
when I'm representing executives. Absolutely.
Okay. And that's not uncommon in your experience to actually be able to get that?
Absolutely.
So this is, again, valuable piece of information for entrepreneurs out there and founders. Okay, so let's talk a little bit about where do non-competes come in and why are they significant here in California?
So non-competes are significant here in California because they're illegal.
Yeah.
Okay, unless somebody is selling all of their equity interest in a corporation.
Yeah.
Okay, which makes sense. If you think about it, if I'm coming in to buy a company, I shouldn't allow the individual who owns all the stock to, the next day open up business across the street from you.
Right.
So there's some very limited situations where non-competes are enforced, and that's one of them. You have to
Yeah.
sell all of your equity interest in a company. The company buying it has to actually be in that business.
Okay.
Every other type of non-compete is illegal in California in every situation. And by the way, not just non-compete in terms of you can't be in a competitive business, but it also prohibits a company, for example, from asking an individual not to solicit the company's customers after
Yeah.
the individual leaves employment. Now, let me make one thing clear. While you are employed, the law says you cannot compete with your employer.
Right.
Okay? This relates to post-employment activities. So what happens when you're no longer employed?
Right.
And that's when the ban on non-competes comes into play.
Okay.
Another important exception, of course, trade secrets are protected in California, and you are not allowed to use somebody else's trade secrets after or either during employment, of course, or after you leave employment.
Yeah.
So that's another kind of exception to the non-compete rule. It's my experience, and I say this coming from practicing in New York for 25 years and moving to California a couple of years ago, how many both companies and executives are unaware of this ban who come into California, engage executives here or buy companies here, and they don't even realize that there is this law in the books here in California. It is truly amazing to me how many people are just completely ignorant of that fact.
Now, I mean, most companies, including like a lot of even small tech companies and internet companies, they're global or at least, nationwide in terms of their presence.
Yes.
So let's say I'm physically employed in California, but I open up a shop and I'm, doing stuff in New York or
Sure.
doing business in New Jersey or some other state that doesn't have this restrictive, you can't have a non-compete. Can a company that I've sold my company to come after me and say, even though you're living in California, you're doing business in New York or New Jersey, so therefore you're violating some kind of non-compete that I have with you?
Right. So the question you're asking comes up almost every day.
Yeah.
And there's no, I can't give you one straight answer on it other than to say that if you are domiciled in California and you have the protection of California law, you have a very good argument that enforcing that provision anywhere in the country is a violation of California's public policy and therefore should not be enforced.
Okay.
It can lead to some very complicated and lengthy and expensive litigation.
Has there been any case law established around these kinds of things?
Yes, there's
Okay.
a substantial amount, and that's another video for you.
Okay. Okay, awesome. So tell me a little about, severance, continuation of salary
Yes.
or lump sum payments
Yes.
or, what do you see as kind of the severance provisions that you're normally seeing today
Right.
for founders, CEOs,
Yeah.
and C-suite executives?
Right. So there's no one formula that I see. I would say, generally speaking, less than a year is the maximum, or a year or less is the maximum that you typically see.
Okay.
What is severance? Severance is entitled to provide income replacement in the event you suddenly have a job loss.
Yeah.
Okay, that's what severance is. It's
Yeah.
not intended to really benefit you financially or provide a tremendous amount of money in your pocket, so to speak.
Sure.
That's where the equity acceleration comes in.
Right, right.
That's why you get involved in startups, and
Sure.
that's
Yeah.
where the financial value is. But
Yeah.
severance is just intended to give you a little bit of cushion while you go out there and look for a new job.
Right. So 6 months to a year is
Yes,
pretty common?
generally speaking.
Okay.
One thing I am seeing a lot of these days is severance only kicking in after a certain period of time. So the executive has to come in, prove their worth,
Yeah.
so to speak, for a couple of months. And then after they've been at the company for a couple of months, at that point, if they're terminated, severance might kick in. So whether it's 6 months or a year,
Right.
it kind of makes sense. It gives individuals and companies a time to kind of, get to know each other.
Right.
In an extended job interview.
Right. Okay. Makes sense. But that's also, you as an executive, especially if you're leaving a high-paying executive position in a larger company and
Yes.
coming into a startup, you really have to be careful about how you negotiate those things.
That's absolutely right.
It's, everybody, it's like, hey, let's make sure we really know each other before
Yes.
we get in this arrangement so I don't put myself and my family at risk
Exactly.
by coming into this deal.
Exactly.
Okay. What about other goodies, health benefits, COBRA payments, you see those as being,
Right.
You get your personal computer.
Right. Well, I think typically on the COBRA payments,
Yeah.
you would negotiate that the company would provide the same level of health insurance that you would have from a financial perspective for
Right.
the duration of your severance. I
Okay.
think that's kind of a starting point.
Yeah.
As you can appreciate, as everybody can appreciate, the cost of monthly health insurance is
Yeah.
extremely high and rising. So,
Yeah.
this becomes a subject of negotiation, and there may be certain tax implications as a result. So that's
Right.
something else to keep in mind.
Okay, cool. Well, tell us a little bit about yourself and what you do for fun other than being a litigator and all that kind of stuff.
That's true. That's trial practice is the best part. So moved to California from New York a couple of years ago and have taken full on the California lifestyle. So
That's
I enjoy
awesome.
surfing, paddleboarding, sailing.
Oh, that's awesome.
And most particularly taking my dogs to Dog Beach,
Yeah.
which I think is a purely California thing
Yeah.
and totally enjoyable. So
That's
yes,
awesome.
Yes.
Well, I mean, it's clear to me that employment agreements are critical. My experience, you get one chance to get it in place.
That's right.
I think you really need to get a competent attorney to help you negotiate them, and also to make sure that you're in compliance with all the tax provisions
Yes.
and everything like that.
Mhm.
And this is something that as an employer you want to have
Yes.
with basically all your employees.
Mhm.
As a board of director, I think it's important to have these things up front with your executives,
Yes.
so you have clarity if you're
Mhm.
investing in companies with the founders,
Right.
so everybody knows what's coming.
Yes.
And was there anything else that you'd like to add that you think is critical or that we missed?
I think that my one word of caution, don't take your friend's employment agreement and kind of insert your name and terms. More and more these days, as I mentioned, I keep talking about the tax situation.
Yeah.
It's very, very important that you have a compliant employment agreement. You do not want to find out later that you do not, because it actually cannot be fixed.
Yeah.
Okay? So that's my
It's
one.
not just tax, it's penalty associated with it.
Exactly. This happens every couple of months. This happens where
Wow.
something comes across my desk and somebody says, well, can't we just amend it? The answer is no, you can't amend it in many circumstances.
Yeah.
So that's my word of caution. Get that advice up front before you sign.
Okay, awesome. Well, I want to thank Jen for being with us today.
Thank
This
you.
has been really informative and educational, and I hope valuable for the entrepreneurs out there. So this is Patrick Henry, the CEO of QuestFusion, with the Real Deal What Matters.